Peace to Yahweh. Peace to Yahweh. What's going on? This is your man, Jonah Bay, and you're listening to Consultation Wednesday, where I take questions and give answers to law questions. We have an upcoming webinar. It's on March 8th. And what is it called? Hold on, let me pull it up. I forgot what the flyer says. All right, is court case reversal before and after judgment webinar. It's $200. You can buy your tickets at jonahbay.com. Once again, court case reversal before and after judgment is a webinar. It's on March 8th. It's $200. You can buy your tickets at jonahbay.com. You don't want to miss it because a lot of y'all need to reverse cases. It doesn't matter if you got an old ass felony, whatever. You need to go back and reverse it. Then, when you get it reversed, you can do a 241, 242 suit, and you can get the webinar for the 241, 242 suit from jonahbay.com once again. So today is Consultation Wednesday, where I just take mad questions from people. And people call in and give testimonies and stuff like that. But I want you all aware of, if you know the Constitution and they violated due process of Constitution, you shut that case down, plain and simple. Someone in one of the chats that we do, in one of the bills that we do, was like, yo, he's just trying to get money from people. How the hell you gonna reverse a judgment before it's a judgment? That's impossible. Obviously, this motherfucker don't know nothing about Constitution or law or anything else. Because let me ask y'all a question. Y'all do know y'all can bring up jurisdiction at any time, right? And if they were found to have a lack of jurisdiction, wouldn't that get rid of the case even before it was a judgment? Of course it would. The problem is y'all haven't known how to present it to make that happen. Y'all don't know the Constitution good enough to make that happen. Y'all don't know the Supreme case laws to make that happen. It's a lack of knowledge is the reason why you can't do it. It's not the fact that it can't be done. You see what I'm saying? So I'm going to put y'all on to a few little Supreme Court cases tonight. I hope y'all are taking notes, because I'm going to go through it somewhat kind of quick. All laws, rules, practices are repugnant to the Constitution are null and void. Marbury versus Madison. And that was in 1803 in the Fifth Circuit of the U.S. Court, Supreme Court. So anything that goes against the Constitution is repugnant. All right? Y'all gonna need that. Put in your brief. 2, common law is the real law, the supreme law of the land. The codes, rules, regulations, policies, and statutes are not law. Y'all definitely need that one. And it's self versus Rahe. 61 WN 2D 261. Their statutes, codes, and rules and regulations are not law. They're policies. They're not higher than the Constitution and never could be. The Supreme Court case rules, Supreme Court already ruled on it and said it can't be. Those aren't laws. Y'all haven't been using them either. Right? Number 3. All codes, rules, regulations are for government authorities only, not human creators, in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking due process. Rodriguez versus Ray Donovan, U.S. Department of Labor case, and it was in 1985. 769 F2D 1344 and 1348. That's right. That's 2 cases that tell you that statutes, codes, rules, and regulations are not law and they're unconstitutional. Supreme Court already declared that all of it was unconstitutional. So who really has the problem? The problem is y'all not enforcing it. Or the problem is y'all don't know how to enforce it. This is why I do webinars and stuff like that to teach y'all how. Teach you the law and teach you how. And then y'all want to call me cocky because I know how to do it and it works. And I teach people. People want to be mad at me. Why? I'm helping you. I'm helping you. These other people ain't telling you the court cases. They ain't telling you what the Constitution says and all that. I can show you in the actual Constitution. Hold on. Let me go to the Georgia Constitution and show you something. Because that case law was based off of the Constitution itself. I don't know if y'all know that. I don't think y'all really be getting it. They take the Constitution, they codified it, and hide it. I'll show you right here. Give me a second. See, I know the Constitution through and through. I know case laws. I even know Georgia codes. And I recite them all the time. Man, it's been so long. I'm trying to remember where it says it. I can't remember it right now, and I apologize for that, but it's definitely in this Georgia Constitution. I wish it had a search engine where I could search it, but it doesn't have a search engine. But Anything that goes against the Constitution is void. That's what it says. Right? Now, they codified it and ruled on it in the Supreme Court. But let me go to some other ones. 4, a person has a property right in the use of his or her name, which a person may transfer or assign. Gracie versus Madden. The case was in 1989 in a Tennessee court. They don't have the right to use your name, especially if you have copyrighted your name, because the name is for a person. The person is the legal person, right? It's not you, the flesh and blood. Flesh and blood can own it and assign it to whoever. Matter of fact, every time that y'all do a contract, an application, y'all are assigning the name to someone. Did you know that? And you have the right to do it. Rodriguez. Now, why would someone be hit me up now? And that was Gracie versus Madden. Gracie versus Madden. Had the right to your name. 5, a judgment is void if the court acted in a manner inconsistent with due process. A void judgment is a nullity and may be vacated at any time. So when dude was talking about how you gonna get rid of a case before judgment, right? Marriage versus Hampshire breaks down that is void if it went against the Constitution. All you got to do is know how to enforce that through their rules and regulations. It's not hard to do if you know what you're doing and you know the Constitution and you know the case laws, how to write the brief, right? Number 6, subject matter jurisdiction. Because it involves a court's power to hear a case, can never be fortified or waived. Consequently, defects in subject matter jurisdiction require correction, regardless whether an error was raised in the district court. United States versus Cotton. And this was in 1974. Right? That's another thing that can reverse a case or get rid of a case before they did their judgment or after they did their judgment. Did they have subject matter jurisdiction? See, on jonahbay.com, I have a document called the writ of discovery. In my writ of discovery, it talks about what the Constitution says they need to pull you over in the first place or arrest you. A warrant with an affidavit in support of the warrant of someone who was harmed is what the Constitution says. And if they don't have that, they lack subject matter jurisdiction and personal jurisdiction. And then you would cite this case, United States versus Cotton. Real fucking simple, y'all. But it's simple for me. I've been on this shit for 20 years. I know I started late. As I'm 53, about to be 54. So I started when I was in 34. That was late. But I had no need to really dive deep into the system came after me and gave me problems. All right. Number 7, a court may, and don't think I'm reading from any other document. I created this document myself and numbered it, right? of all the different court cases I know of that proves that what they're doing is unconstitutional. It says a court must vacate any judgment entered in excess of its jurisdiction. And that's Burrell versus Henderson, 2006. So if you can prove that they don't have a warrant and affidavit, which you asked them for and they never produced it, they are supposed to immediately vacate. And this is what you recite. A court must vacate a judgment entered excess of its jurisdiction. Burrell versus Henderson. You can get a certified copy of it, or you can just quote it, right? Number 8. Denying a motion to vacate a void judgment is a per se abuse of discretion. State versus Swigger, 1995. It's illegal for them not to vacate it. But you have to be able to recite these things very simply, to make them do it and follow the rules. Right? If the trial court was without subject matter jurisdiction of the defendant's case, his conviction and sentence would be void ab initio. So you got me telling you, you got the Supreme Court telling you, you got the Constitution telling you, you got court cases telling you. But I know what it is. Y'all scared of these people. Y'all scared of the lawyers and the judges and all that. The bailiffs, the sheriffs, everyone in court. Y'all scared. Number 9. Courts are constituted by the authority, and they cannot go beyond that power delegated to them. If they act beyond that authority, and certainly in contravention of it, their judgments and orders are regarded as nullities. They are not voidable, but simply void. And this is even prior to reversal. William versus Berry, 1850 case. Are y'all starting to get it now? Are y'all really starting to comprehend what I'm putting down? All right. 10. It may be that it is obnoxious, the obnoxious thing in the mildest form, but illegitimate and unconstitutional practice get their first footing in that way, namely by silent approaches and slight deviations from legal modes of procedure. This can only be obligated by adhering to the rule that the constitutional provisions for the securities of persons' properties should be literally construed. A close and literal construction deprives them of half their efficacy and leads to the gradual deprecation of the right, as it is consistent more in sound than in substance. It is the duty of the courts to be watchful for the constitutional rights of the citizens and against the stealthy encroachments thereon. Their motto should be Obsta Principles. Boyd versus United States, 1885. See, the case laws is there. You know, and you got a plethora of different case laws. All you got to do is know them or have it in a Word doc. Be ready to use it, and you can beat them. Since the Constitution is intended for observance of the judiciary as well as other departments of government, and the judges are sworn to support its provisions, the courts are not at liberty to overlook or disregard its commands or counteract evasions thereof. It is their duty in authorized proceedings to give full effect to the existing Constitution and to obey all constitutional provisions, irrespective of their opinion as to the wisdom or disparability of such provisions, or irrespective of the consequences. Thus, it is said that the court should be in our alert to enforce the provisions of the United States Constitution and guard against their infringement by legislative, fiat, or otherwise. In accordance with the basis principles, the rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with delivered judgment of the tribunal before which the validity of the enactment it is directly drawn into rule. It is the duty of the courts to declare that the Constitution and not the state governs cases before them for judgment. And that came out of 16 Amjur 2D, section 155, right? These people know the rules. They jerking you and going against your knowledge. They know you don't know. It's a saying. It's a maximum law. The only people that have rights is the people who know how to enforce it. Your lack of knowledge, being able to enforce it, makes it where you don't have the rights. 12. There is a canon of legislative construction which teaches Congress that unless a contrary intent appears, legislation, it is meant to apply only with the territorial jurisdiction of the United States. U.S. versus Speller, 1949. All U.S. codes only apply to the United States, the 10 square miles. Yeah. Supreme Court already said it in 1949. Have y'all used that? How many of y'all have had a federal case against you? Right? What y'all call it? I got convicted. I got the grand jury came down and I forget what it's called. A federal grand jury indicted me. How many of y'all got indicted? Well, if you'd have known this, U.S. versus Speller, you'd been like, yo, I don't live in Washington, D.C., 10 square miles. That rule don't apply to me. None of them codes apply to me. How do you even have a case? I'm not in your jurisdiction. I don't live there. Lack of knowledge is doing y'all in, man. Yeah, I know. Yeah, Jonah, you so fucking cocky. Damn right I'm cocky. I know what I'm supposed to know. Jordan was cocky when he said, I'm going to win. I'm going to dunk on your ass. I'm going to hit this fadeaway three on you, right? My sneakers are the highest selling sneakers ever. He says all that shit. That ain't cocky, right? It ain't cocky because it's true. What that is? What? What about it? Oh, go ahead. Go ahead. Go ahead. She could. I'm only talking about Supreme Court cases. Yes, I do. I cuss my ass off. Fuck that shit. Okay. She threw me off, y'all. She came in the door, threw me off. So y'all got to know what to use and when to use it. And the best time to know this information is before you need it. Study before you go to war, right? 13. The laws of Congress in respects to those matters outside of constitutionally delegated powers do not extend into the territorial limits of the states of the Union, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. Kala versus U.S., 1894. That's another case telling you that their laws, U.S. codes and all that, only apply to Washington, D.C., the Virgin Islands, Hawaii, but not the 50 states. The Supreme Court already said that. Yeah. These are things you don't know. So only really the state can come after you. And then the state be having jurisdictional problems. As you will learn when you come to my webinar on March 8th. Get your tickets at jonahbay.com. 14. The right of the whole people, old and young, men and women and boys, and not militia only, to keep and bear arms, every description, and not such merely as are used by the militia, shall not be infringed, curtailed, or broken in upon in the smallest degree. In the smallest degree. That means they can't even make you get a goddamn license to hold a gun. It's a constitutional right. But let me go on. Shall not be infringed, curtailed, or broken in upon in the smallest degree. And all this for the important end to be attained. The rearing up and qualifying a well-regulated militia, so vitally necessary to the security of the free state. Our opinion is that any law, state or federal, is repugnant to the Constitution and void, which contravenes this right originally belonging to the forefathers trampled under the foot of Charles I and his two wicked sons successors, reestablished by the Revolution of 1688, conveyed to this land a liberty by the colonists, and finally incorporated conspicuously in our own Magna Carta, District of Columbia versus Heller, 2008. Y'all live in New York, y'all always had the right to bear arms, even though they're trying to say you can't. I had a case in New York where a brother had a gun on his hip, acting like he was a Martian. And I wrote up the brief and all that, told him they lacked jurisdiction and all that to stop him and all that, lock him up and all that. He was a felon. Nowhere in the Constitution does it say that a felon, they can take the rights of a felon and never give them back. That's unconstitutional what they did. So when I beat his case, what happened was then they gave y'all the right in New York to have guns, but y'all had to get a license. The work ain't over. The work ain't over. Y'all need to use this to say, nah, you can't limit me for having a gun with a license. It's not a privilege. It's not a privilege. Columbia, District of Columbia, Washington, D.C. versus Heller, 2008. 15. There, every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Cruden versus Neal, 1796. They need your consent. Now, I've been told y'all that in my injunction, travel injunction. I showed you in the Constitution that they can't have you under a social security number or a birth certificate. Why? Because you as a baby had to consent, and a baby can't consent. Right? Called the Baby Act. The Baby Act. Babies can't consent to nothing. They can't even talk. If you didn't sign it, you're not bound by it. Now, y'all do know that every state is a municipal corporation. So all its counties and all that are municipal corporations. Municipal corporations is the same as the District of Columbia Corporation. It's a subsidiary of what y'all call the United States Corporation. You didn't sign on to be a citizen of the state of Georgia, the state of New York. Those are corporations. That right there will make it where they don't have jurisdiction. Did you know that? That right there. Well, we at the 30 mark. Let me open up the call lines and see what's going on out there. I think I went through enough. We'll do some more. We'll do this again. Hold on. Let me find out where I left off. 17. When I read it again, I have to start at 17. Let me see what's going on in YouTube. Monday, I didn't even look at. Talk Shoe says no show. Yeah, I didn't even try to get on Talk Shoe. Talk Shoe been acting a fool, and since it's free, I'm like, I can't even beef with them because it's free. So we are on, if you're a part of the Telegram group, you can go into Telegram group, the $1 Billion Bill, and it will give you the link in the Telegram group that you can call in and talk to me on GoToMeeting. Can we use this process if we lose in court for an accident? Yes, you can if they violated your rights protected by the Constitution. This is for civil and criminal. Work for all of them. Well, that's all that was in YouTube. Shit. I'd be wondering if y'all ain't got no comments, no questions. Do y'all really be understanding what I'm putting down? Y'all should. I make it as simple as I can. Anyone can use a trademark name unless they are making money off your name or similar. A law repugnant to the Constitution is void is a quote from the 18th Office of Supreme Court. This case establishes the principle of judicial review, which gives the Supreme Court the power to declare laws unconstitutional. They are right. I ain't got nothing. They just put in comments. They didn't even say nothing. They ain't had no question. They just made a comment. Y'all could do that too. Can make a comment, even if you ain't got no question. What if we sign a plea agreement? Now, that's a good question. But if they never had jurisdiction in the first place, if it was fraud done in the first place, fraud gets rid of everything. And it was fraudulent if they went against the Constitution. Reverse them if you can prove that, right? People really don't be having shit to say. Let me open up the call lines. One hand raised. All right. Enoch L, what up? Call lines is open. Can he come in? Let me see if I can unlock everyone's mic. I can't hear you, Enoch. Are you? Oh, there you go. There you go.
Oh, yeah, and no hubcaps either because those age into the tires. Still, I love the thing. I think it looks really
Hold on
cool.
one
That's
second.
why I wanted it so badly.
That was my mess up. Enoch, can you hear me now? I still can't hear him. His mic is open. All right, let me.
Yeah, okay.
Oh, there you go. There you go. Whatever you do, you just did, do it again.
Peace, can you hear me?
Yes, I can now. What's up? Yo, it was me messing up. I had the whole computer muted out. That was my bad.
It's all good. I actually came off my iPad and just came right back on my phone just to make sure. But how you doing?
I'm doing wonderful, magnificent, and great, my brother. How you doing?
I'm doing wonderful, magnificent, and great myself.
I'm
filled with gratitude for large sums of money flowing into my life every day, and I wish the same for you and your family.
Yes, sir. Thank you, my brother.
Yeah, I like the information you was dropping with the Supreme Court cases. You know, everything is based off the Constitution.
Mm-hmm. That's all I look at because, you know, me, all my remedies are based off the Constitution. I could care less about all that other stuff, their codes and all that. Now, I only use their codes to follow their so-called court procedures.
Right. And, yeah, it was in Article 1, Section 2, Paragraph 5 that says that any legislative act that violates the Constitution is void.
Is that 1877 Georgia Constitution?